You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column, available on BloombergLaw.com, and it's also on the Bloomberg Terminal. We're talking about MF Global today. Lots to go over. First up, Bill, the Chapter 11 trustee for the case, Free, has asked the SIPC trustee, Giddens, to be, quote, more transparent about the general status of the case. I'm not sure what to make of that statement. Is that a euphemism or something, or what's going on here? I would imagine they would talk every day.
Yeah, it's a wonderful euphemism. And you have to read these court papers more between the line than line by line. And what I'm seeing, and it's a bit of a surprise, is something of a rift growing between these trustees. Keep in mind, you've got Louis Free, a big personality, the former director of the FBI and a former federal district judge, who was a Chapter 11 trustee for the MF Global parent. Mm-hmm. Then you have James Giddens, who is the trustee for the brokerage subsidiary. And Mr. Giddens is, by all accounts, the most experienced brokerage liquidator on God's earth. The Free trustee filed some papers in which, as you said, he's asking for more transparency at the level of the brokerage. He says, among other things, that Giddens, the brokerage trustee, has said there's a $1.6 billion shortfall in money that should have been held aside for customers. On the other hand, Free says, the commodity exchange has said the shortfall is $600 million, a mere $1 billion difference. Mm. And Mr. Free is asking, and I suppose properly so, how come the difference? What explains the difference? Have you found the other $1 billion, but you can't say where it is or why you can't turn it over? What's going on here? Further, Trustee Free says there is not enough information that's been made public to know whether the next distribution that's supposed to bring the recovery by customers to about 80% is too much, too little, or otherwise. He says there just isn't enough information to know if the set-asides or the holdbacks are too much or too little. And frankly, I'm finding this a bit surprising, because you would have thought that the two folks would be more on the same page at this stage of the game. Because let's face it, we are now 5 months, almost 6 months into this case, and the public has not yet been told where's the money. Yeah. Or, for that matter, Lee, if they know where the money is, why don't they tell us where the money is, but then go about explaining why they can't get it? That's the big issue. And as we said before on these podcasts, one of these days, if we're told, as I suspect, that they know where the money is, but it's not legally possible to get it back, oh, brother, is there going to be a conflagration when that happens? Yeah,
I haven't seen a case quite like this at all. One customer in particular, a company by the name of Saperi, has been pushing hard on the holding company for better treatment for all customers. What's going on there?
That's a very interesting subject. You know, there are a number of customers that have hired lawyers and appear in court frequently. Some people think they're creative. Others think they're crackpot. But I'm going to tell you, these folks at Superior Wealth Management, who are out of pocket some $90-odd million, are really raising some issues where I think they're probably going to lose in court, but nonetheless, it's an issue that's well worth looking at. They are arguing that the holding company, which is not a broker-dealer, should nonetheless be governed by the distribution standards that apply to busted brokerages, so that, as a result, customers would be the top dogs on the pecking order and receive a much higher distribution from the holding company. Frankly, it really seems to me, and this isn't just my opinion, it's the bankruptcy judges as well, that the law simply doesn't permit it because the holding company is not in Chapter 7 and it's not a broker. But nonetheless, this is an issue that perhaps is something Congress ought to look at. Question, as I see it, is pretty much like this, Lee. Let's assume you have a family of companies, including a broker that goes down the toilet. Can this family of companies squirrel away assets at non-brokerage affiliates so that that money can't go to customers? Or should Congress sit down and say, listen, if you have a broker that goes bust, the first monies for any of the companies, even the non-brokers, ought to go to the brokerage customers. This, of course, would make brokerage customers much happier, but not the creditors of non-brokerage companies. But this is a political issue. I'm sad to say I don't think it's an issue that the courts can solve, but this is maybe something that ought to be looked at in Congress.
Now, when talking about Saperi, I was talking to some other people who seem to think that this firm initially wanted this case to be a Chapter 7 rather than a Chapter 11.
Well, I thought from the outset, Lee, that there was a very good argument to be made for converting the parent case to a liquidation in Chapter 7, because I don't know how in God's name you're ever going to reorganize this puppy in a traditional sense other than liquidate the assets. But oddly enough, the Saperi people did not make a motion for conversion. The bankruptcy judge said in his opinion in early February that had they made the motion, he would have denied it right now. But you wonder why at some point the creditors don't stand up and make a motion for conversion. I think the answer may be later in the case that until we know that we can't utilize net operating losses in some kind of reorganization plan, maybe the best thing in the meantime is to leave it in Chapter 7. But if you find you can never utilize the NOLs, well, then maybe you chuck it into 7.
All right. Very interesting stuff. I'm sure we'll be talking about this case for a long time. Bill, thanks for stopping by. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can follow our updates on Twitter and see more of our videos on YouTube. I'm Pacchia. Thanks for watching.